want to interrupt this carefully laid out game plan you folks were crafting, and I was kind of admiring the way Mr. Williams, that you were, you were, okay, you do this, you do that, and obviously the more organized we are, the more productive we'll be. So with that, I will call this meeting of the subcommittee for HB 621 to order. As is our custom in the Health and Human Services Committee, I'd ask you to begin with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everyone, and thank you all for being here. In addition to myself, I think I guess our nameplates are in front of us, but I want to thank Representative Lamontagne for being here today and agreeing to serve on this subcommittee, and also to serve as clerk today, and also thank Representative Markell for also agreeing to serve. As indicated, this is the subcommittee on HB 621, and I know that we had some discussion during the decision in the executive committee we had a few months ago about retaining it. At the time, SB 92 was pending, and it was noted that there were certain similarities that might address the concerns that were being expressed by the department and also by others. And for the benefit of everyone, there's a side-by-side comparison over on the table there. And, if you don't have one, you're certainly welcome to take one. But I know many representatives of the department are here today, and that's going to certainly help our discussion and our work and our considerations. And again, Attorney Williams, I want to call you representative. I'm sure you're going to make a lot more money in your current position than you would in that one. But Attorney Williams, if you want to, offer your input on the two bills and why 621 is still needed. There's a strong feeling that 621 might still be needed or desirable, even with the passage of SB 92. And obviously, before we make any decisions or recommendations to the full HHS committee, we want to hear the department's thoughts on this. Please proceed.
And Chairman McDonald and members of the subcommittee, thank you for this opportunity to come before you today on retain HB 621. For the record, my name is John Williams. I am the Legislative Director for Health and Human Services. And it's one of those where we hit the reset button because you heard the bill originally back in March, and as time goes on, you had a lot of things happening. So really today what we would like to do, Chairman McDonald, is to help you folks level set where we left off in the conversation, just as a brief refresher over the concerns that the agency, our department, had with legislation. This was as one of the few bills that we as a department actually took a position in opposing because of the nature and kind, not only in terms of the fiscal impact, and you'll hear some very high level overviews from members of the department to come before you to explain where those fiscal implications are, but also from a policy perspective. It's really important to see if you're going to pass legislation, how does it actually benefit the individuals that are out there in our state and improve their health and well-being. This is a bill that was at least originally intended, based upon the conversations had at the public hearing, to protect privacy interests and give the birth mother the opportunity to elect not answering either one or all of the questions on the birth worksheet. That bill obviously had some issues and problem, and your committee decided on March 19th to retain the bill so you could have a further conversation, which is happening today on this wonderful October day, to further discuss what, if anything, about this bill should either proceed forward or perhaps be looked at in a little bit more in-depth detail, perhaps maybe in an interim study format. With that contrasted, your committee did hear a bill that came over from the Senate. It was about a couple of weeks after you had retained this bill, and it was Senate Bill 92. Now, in comparing the two bills, the subject matter is the same, that both of the bills had a piece of it that dealt with the birth worksheet. And you do have copies of Senate Bill 92 that are in front of you that you can refresh your recollection, but there were sections 1 and 2 of the bill dealt with the APGAR, and it actually improved public health and the fact that there is going to be a APGAR within the 5, and then you'll see the amendment adding to a 10-minute time frame. In addition to that, it did touch upon in Section 3 of the bill as it related to the birth worksheet. Very thoughtfully, Senator Rosenwald, who is a prime sponsor for the bill, met with the Secretary of State's office, the department, and also with representatives from the federal government, from the Centers for Disease Control, and had a very robust conversation and a very thoughtful conversation relative to what information, if any, does the CDC need for their purposes. And you'll see reflected in what was passed in Senate Bill 92 was a very, very thoughtful approach to narrow the amount of information that would be provided to the CDC. And so with that, I think your committee did a very great job. The governor obviously liked it as well and signed it into law, so it's passed into law. And so good work did come out from that particular bill. Is it exactly the same as you see on the side-by-side that was prepared by Attorney Grant, your committee researcher? No, they really are different bills, but they deal with the same subject matter in terms of honoring privacy interests of the mom and limiting information. But the problems that are had, and you'll hear more detail with HB 621, are significant enough that the department actually took, and again, out of the 500 plus bills we tracked this session, there was only a handful that we actually took a position on a bill to oppose. And so with that, I'd like Chairman McDonald, if I could invite up members from the department, from the Division for Public Health, and have them explain a very high level just to answer questions you might have relative to where we left off back in March on the testimony with the bill. And then when they are finished, we have representatives from our Division of Economic Stability, as well as the Division for Program Quality and Improvement, as to why this bill, if it were to go forward in its current form, would be incredibly, and I can't underscore it more, incredibly problematic for the citizens of New Hampshire, the people you represent, the people we serve as an executive branch agency. So if you don't have any questions for me, which I'm seeing great attention and great eye contact, that I would like to turn it over to Ms. Abby Rogers, who is our legislative liaison for the Division for Public Health. And I have to say, Abby does an incredible job. If you think I'm good at coordinating, you have not seen anything until you've seen Ms. Rogers.
Before you go, Representative Markell, did you have a question for
Yes, I do. And yes, I do. Thank you, Mr. Chairman. And thank you for taking my question. Based on my reading of the bill, what we're really talking about here is a right to privacy. Is that fair to say?
I believe that the intention from the prime sponsor was to look at the issue from the mother's perspective in terms of the information that's provided in the worksheet. So it does touch upon the issues of privacy and privacy concerns. And as we had mentioned before in our prior conversations, that the department and not only our agency, but I'm sure you'll hear from the Secretary of State's office, take very seriously the issue of protecting either personal identifiable information or PHI. And I think that was part of our testimony and questions we had at the public hearing as well. So you'll have members from the department who will be much better able to address that question.
Okay. Can I, okay, just one follow-up question? Okay, so let me just ask you this question. As an attorney, if this bill were not to pass and somebody were to refuse to provide the information, okay, and assume these facts for a court challenge, would it be likely that what standard of review for the constitutionality under a right of privacy do you think would apply if some kind of petition were brought before the New Hampshire Supreme Court? And how do you think they would analyze this? Either rational basis review, strict scrutiny, or intermediate scrutiny, and why?
And Chairman McDonald, I did attend law school, so I did take constitutional law, and I did pass that portion of the bar exam to the extent that we talked about the different levels of scrutiny.
Okay.
I would have to say that obviously it is a very personal related privacy interest, so it probably does have a heightened strict scrutiny analysis. But I would actually, if this is one of those rare occasions where I know it's not permitted, but I'm going to ask the indulgence of the chair, may I ask Representative Markle from his research what his opinion is in terms of what standard of review would apply?
Okay. The only thing that I found that was even remotely close, because as it was pointed out here, that there doesn't seem to be any law congruent on point anywhere else in the United States. So I did see something from the United States Supreme Court back in 2019, which is only roughly analogous, which was a question that appeared on the census, which is whether or not the census people could ask you whether or not you had citizenship and whether they could be compelled to do it. And for a variety of reasons, it looks to me as though under a slightly different analysis, the answer was no, they couldn't. That was a Roberts opinion, and that was 2019. So I guess what we're asking here is how would a court likely review it? If it's and then again, a question of whether or not you're going to analyze it under the federal constitution, or you're going to analyze it as a matter under the Supreme Court, under the New Hampshire Constitution, because it's likely that the New Hampshire Constitution would probably grant more rights than the federal Constitution would in this particular matter. Would you tend to agree with that?
Because you had parsed out many things, I can't just say a general, I agree with everything, but I do appreciate the update on your review, and I would agree that there would be a slightly different standard of review under the New Hampshire State Constitution, because particularly with the amendment from 2018 added to the Constitution around privacy rights. Also, not having the benefit that you have to reviewing the decisions, I do know that in a large amount of constitutional law decisions relative to government action, that if there's a rational basis, in other words, there's actually an intended basis to help the citizens, and in this case, through public health surveillance, that they may apply a different standard of review, but that's for a conversation for a different day.
Yeah.
One of the things that I do think helpful as a practical matter isn't just the legal discussion, which this is absolutely wonderful to be having this kind of an exchange, is on a practical level what happens, because we live in a real world, and when mothers are giving birth and going through the process, I am sure there are occasions in real life practices that you could probably refer to one of our folks from the department to ask what happens if in the event that somebody elects not to want to provide information on a particular question. I'm sure that must happen on a fairly frequent basis, and I'm thinking there is probably in real life experiences a real life response to that versus a legal constitutional level review response.
So I guess it might be fair to summarize, to be able to say whether, okay, so obviously what's going to be fatal to the statute is the standard of review that it gets, as it is frequently. And I guess the other question might be whether this constitutes an undue burden on the right to privacy. Would that be a fair assessment?
With the caveat that this is a very bad bill, and I'm very clearly trying to communicate that to you, and would hope that it would not go forward to test the constitutional waters here. But I think your observations are quite astute.
Oh, thank you, sir. No further questions.
Okay, thank you. Representative Lamontagne, did you have any questions? Okay, thank you, Attorney Williams. Chair recognizes Ms. Rogers, and I'll let the other ladies. The lady in the middle, I'm always afraid to pronounce your name because I know I can't do it justice. So,
Good morning. My name is Abby Rogers. I'm the legislative liaison for the Division of Public Health Services. Thank you, John, for the introduction to why we're here today. I'm joined by my colleagues, so I will let them introduce themselves to you.
Good morning. Excuse me. Good morning. My name is Jiahui Chawla. I'm the Bureau Chief of Public Health Statistics and Informatics in the Division of Public Health.
Good morning, I'm Courtney Keene with the Bureau of Family Health and Nutrition in Public Health.
Thank you. So following up on John's introduction of why we're here, as you may remember, the department did have significant concerns with HB 621. Just to level set a little bit on the live birth worksheet, just wanted to let you know that every state in the country collects this information. It is baseline maternal child health information that is collected for the Bureau of National Statistics to inform how the country is doing in maternal and child health. So New Hampshire is not, every state collects this data. And our concerns around it for the personal identifiers, just to clarify a little bit, is there is information on the live birth worksheet that is for the birth certificate, is to fill out the birth certificate. And currently in law, that is required by law that birth certificate is completed with demographic information to inform mother, father, to register the child as being born and having citizenship very important for that. Also to prevent trafficking. If you weren't to fill out a birth certificate, that would be obviously a big problem. The maternal child health statistical information that is collected to inform on the state of maternal child health in the country, specifically in New Hampshire. Currently and I saw Ben Bradley here from the Hospital Association. He could probably inform you more, but reviewing the testimony that was given on March 12th on this bill, the sponsor of the bill was here, and in his introduction of the bill, he did say as well that mothers at the bedside, when asked the maternal statistical information about their health or their infant's health, are allowed to say, I'm not interested in answering those questions. They are not. SB 105 that passed in 2025 removed it was a penalty for that information. The statute was sort of inartfully written to cover both the maternal statistical information and the demographic birth information. That felony penalty does still cover the demographic information, but no longer covers the maternal and statistical information. And that was a provision that passed to not only protect privacy for birth mothers, but also to clarify that statute a bit. So just to level set on that, and we do continue to have significant issues with this bill, and it would adversely affect multiple areas of the department. So I'll pass it on to my colleagues to talk about specific concerns related to public health.
Thank you. So the information that I'm going to provide is how public health is using this critical vital records birth data in our program area and how we provide the service, including the statistical reporting. So vital statistics system essential public health, public infrastructure, The birth worksheet is administered by hospitals, birthing centers, attendant physicians, and midwives to collect critical information about newborns and the child's birth mother and father. This includes details about the birth mother's age, health history, pregnancy complications, the baby's birth weight, health conditions, and also the type of deliveries and other essential informations. Importantly, as part of the birth certificate process, this information helps establish the identity and citizenship of the infant and the legal kinship to the infant's parents. Complete and consistent data is also crucial. So New Hampshire Statute RSA 5C9 states that the Department of Health and Human Services shall have a direct and intangible interest in vital records information in accordance with the provision of the statute RSA 12624C. So why does the department need those identifiers? The personal identifiers are crucial for linking data across systems and ensuring that public health efforts and social services can be effectively implemented. For example, the department's newborn screening program, which Courtney will address more, relies on these informational identifiers to ensure timely screening and follow-up care for newborns with serious but treatable health conditions. So without those identifiers, crucial health intervention may be delayed and the newborn may be will put at risk. Another use case by the department for the to use the personal identifiers, which are also important, is that it is not only to determine eligibility, but also to avoid frauds and ensure that public services and funds are dedicated to the eligible New Hampshire citizens. We have other divisions from the department will address that part on the eligibility more. So from the statistic point, I'm sorry, if this bill is passed, first of all, this is not clear how, what information the birth mother can opt out of sharing, especially regarding the personal identifiers and the minimum amount of data needed for public health purposes. So could they opt out only their first name or last name or piece of date of birth or zip code, a town? Any information that they opt out would make the vital records birth data incomplete. The department will no longer be able to provide the reliable statistical report to determine, to understand the health status of mothers and infants, including such as preterm birth, low birth weight, and the details that lead to maternal and infant mortality. So it will not allow department to act quickly to ensure that the timely life-saving screening for newborn, which Courtney will also address later on after birth for the prevention as well. Another use case from the department to use identifiers, which is the residential addresses. So the Department of Public Health used residential addresses to validate the address in New Hampshire and also to geocode into small geographic areas such as census tract level. Those geographic areas are important to identify the health outcomes in a particular community, along with the demographic information provided through the vital records birth certificate. It is important that for the department to be able to look into these small geographic areas, particularly for the most recent rural health transformation project. The rural areas are identified by census tract level. So without the census tract level data or the data in the census tract level, the department will not be able to respond to the rural health transformation project, and also to be able to provide the support to the needed areas in the rural area as well. So the other part I would like to address is if passed, the HB 621 could undermine the integrity of birth data, impairing the department's ability to track health outcomes, identify the public health trends, and also respond to crisis or public health emergency crisis. So if allowing to allow opt-out, this would introduce inconsistency across the jurisdictions, which is the states, and undermine the standardized data collection. Which could cause inefficiency in data standards between the hospitals and also the state agencies. So other part that is important to note that the privacy of the information at the birth worksheet provided by to the department is carefully protected under HIPAA regulation. So as a HIPAA-covered entity, the department ensures that the security of personal identifiers such as names and addresses, which are used solely for legitimate efforts to deliver public services and also the services from the public health programs. And finally, it is also important to note that HB 621, if passed, could create substantial conflicts with existing New Hampshire statutes, which would also require revisions. The last part I would like to also address is birth data, or the data from birth certificate is an essential database, and also the bottom line fundamental database, not only to identify, the health outcomes in a particular population or areas. It is also used in the federal level to generate population estimates. So if the birth data is incomplete without the information of mother's age, or the information of infant's birth year, month, for example, or even the town zip code, this could create some difficulties in the federal level to estimate the New Hampshire overall population in the town level or in the census tract level. And some consequences probably would be foreseeable for the future actions as well. So that's all I have.
Great.
I'll pass it over to Courtney to address.
All right. I'm going to talk about the newborn screening program here at the state. So if an infant has a screening at the hospital shortly after birth, and that screening comes back as a critical result, we, the program, need to call the provider to relay these results. If we do not have all of the information, because we call the provider, we need to ensure that the infant is established at the provider's office. If we do not have that information to verify that the baby is established with this provider, it can delay the results being interpreted to the provider to then get the care that the infant might need. Some of our conditions are time sensitive, so the faster we know this information can establish the care with the provider, we can then call out the result, and then they can be referred to specialty care. So it's really important that we have this information to be able to continue to make sure this infant has the referral and is seen within a timely manner. I do want to add on to what Joey said, is that with all the uncertainty with funding at the federal level, it is important that we continue to be aware of the fiscal impacts for this bill. As you can see in the written testimony, it is a little over $11 million that could be at risk. Do you guys have any questions you want to add?
Thank you. Yeah, we're here. If you have any questions for us, we'd be happy to address them on anything that we've shared.
Representative Markell?
Thank you. Thank you, Mr. Chairman. And thank you for taking this question. Okay, so we have this information. Okay, can you tell us a little bit about what procedural safeguards are going to be in place to protect this information so it doesn't get disclosed to third parties, number one? The second part of the question is going to be, can you tell me who would have access to this information, either by way of public records request or in the case of somebody actually bringing a case for a variety of reasons, including child support, incidentally, which is mentioned in here, and whether that information is available upon subpoena or court order?
Thank you. Thank you for the questions. So the first part is safeguard the information. So under the existing MOU, the vital records data is transferred from the Division of Vital Record Administration in the Secretary of State electronically to the department. The department has the centralized and also in the state network database that safeguard the entire information. And within the department, we do have different type of staffs to ensure that which staff in the department or in which program has what access. So it's all on user base. So me as a data steward, I do have the access to all the data. But it doesn't mean that I will look at the data every single day, but I do have the authority to review the data access request, identify their justification, why they need this data, on what pieces, for what purpose, for how long, and whether this is legitimate use from the program side. Then I will review and then give my approval, and then to have the IT staff to put this user in the right group of access. The other part of internal data access is that the DOIT, we collaborate with DOIT to create a different type of vital records data table. So for eligibility, they will only have access on the identifiers that they need to determine the eligibility. They don't have access to the health conditions or health informations. And for newborn screening, they also have limited necessary access for a certain data element. So not all programs have the access to the entire data element. So that is a safeguard. In terms of the data release, for the general public or program areas can request aggregate data or de-identified data. For the limited use or confidential use data, it will need to be health-related purpose, and they need to present required documentation, like the application will need to include, this is a research study, what is the study protocol, what is the study design, where the funding is from, and all other required information in the application. They also need to attach an IRB approval or IRB exempt from their own institution to determine whether this research is approved by the IRB board. And also the researchers or the analysts who will use the data will need to provide their own resumes and also why the role of this person, why this person will need to access the data in their research. Everything is gathered and submitted to the department. We will present this request to the Vital Records Privacy Board, which has 6 members. Currently, we have 5 members. But the law says 6 members. 3 are appointed by Secretary of State. 3 are appointed by the Department of Health and Human Services in a monthly meeting to review and discuss. Then the board will provide approval or denial to this specific study. So not everybody can request limited use or confidential use data from Vital Records statistics system or what data or that data. Everything will need to go through the Vital Record Privacy Board review and approval. And if the research or if the project is not tied to health-related research, normally the board will not approve. That is practice. Yes, so 3 members are appointed by the Secretary of State. We do have 1 representative on that board. The other representative, he currently resigned, and also the director from the Division of Vital Records Administration is also on the board. Yes, yes. The name? No, I'm sorry.
Yeah, sorry. I just wanted to share that there are legislative members on that board, on the data privacy board.
Are they both House and Senate or just House or?
They are both House representative. Yeah, and they are appointed by Secretary of State. Where am I? Oh, sorry. So for the limited or confidential data, it will not be released by any other. It will not release to any entities unless they have legitimate reasons. For the general public, it will need to tie to the research purpose.
Follow up.
Sure.
Thank you. Can law enforcement get this information?
Not through the department. I'm not sure whether the Secretary of State also gets that type of request based on the RSA 5C, but I think the director can address the law enforcement.
Is it available on subpoena?
I'm not the law expert, but I believe if a subpoena is submitted to the department, our legal will process that and identify how to respond to the subpoena.
Attorney Williams, would you know that answer? Or? I do not. Attorney Williams is a former prosecutor too, so.
Yeah. Or, for example, but also in the case of a civil subpoena. So, for example, based on some of the information that's required in the child's birth certificate here, and since these letters also reference child support as a key issue, I think one of the pieces of information I would want to get if I was a putative father and I was being pursued for child support would be able to get this information, and that's in the civil context. And for example, to either disprove paternity, and by way of, I won't get into the who shot Johnson, but that I think would be a valid reason to be able to obtain this, particularly with parentage or child support, would be highly relevant to a case. Would you agree with that?
And because we are being recorded, I recognize I needed to go to a microphone to respond.
Okay.
So Chairman McDonald, trying to stay within the scope of the legislation that's actually in front of you right now in terms of it, I think that the question that you're raising is in a civil action for establishment of paternity, for example, that if there was information related to the birth record, I would imagine that there's already, at least in the time that I acted as a supervising attorney for that program area, we never received a request from a law enforcement agency that would require us to go to the Secretary of State's office. We have that information by virtue of the fact that there are public records that are available to us to help us establish paternity. And then also we go through the court process to make sure that the court is overseeing the establishment of paternity. And in cases, it might include also if there is sufficient evidence presented for paternity testing. And I'm looking at your chair because we actually have a fond memory of doing what we call a DNA search warrant, not
More than
related
one.
to child
More
support,
than one.
not related to child support, but relative to welfare fraud investigations. And we did, and Chairman McDonald, he can take legislative notice, not judicial notice, but legislative notice of the fact that we were very successful in front of Judge Robbins to obtaining those warrants, but we did go through the process of doing what was required under both the state and federal constitution as it relates to search and seizure of evidence under the Fourth Amendment. So hopefully you took us back, way back in time, over 20 years of our lives, but yes.
More time than we want to admit in terms of our age, but
Yeah.
if I could jump in for a moment. Paternity is more a question, and child support pursuit is more of a question when, and the form may have changed, but it used to be, I think, the 725, the application for child support services. If they listed the parent on that and applied for the child support, then they pursued it. It wasn't based on the birth worksheet, right? It was based on the application. Is that correct?
And we are fortunate that we have Lisa Dekatowski, who's the director of the bureau chief for the Bureau of Child Support Services and she'll be coming up with the next round of presenters. So perhaps if we could reserve a response to that, unless there's any more questions for these presenters, and then we could have them all come up.
If I could go to you, Ms. Rogers, you and I had a conversation the other day, and a couple of things, and perhaps others in the audience want to speak to this also, but a couple of things we talked about is, I can't remember was it the 773 or whatever it was, and again, some of these may have changed in the 6 years I've been out of the department, but there was a good cause claim form that somebody could opt out in terms of pursuing someone for child support, because that's an important issue. If they were concerned about domestic violence, and I know you and I, for the benefit of Representatives Lamontagne and Representative Markell, if we could revisit that conversation, if you don't mind, so that they know that might figure into this, or may not
Sure.
figure into it.
Yeah, I would love to have Lisa address that, if that's
Okay.
okay. Yeah, that would be probably her subject matter more than me to delve into more of the questions around that.
Okay. And
Thank you.
and the other point you and I talked about the other day that I think that, and we can bring this up numerous times, but Representative Markell raises an excellent point about who gets this information and how is it shared. Kristen Grant shared with me the testimony I offered on HB 105 a few years ago, and confidentiality in the department is very, very important, very critical, can easily lead to termination if an employee violates it. So any information the department collects is not, lightly shared and I know even working with law enforcement over the years, the fraud unit was restricted, Representative Markell, in terms of what we could share with county officials and others in terms of investigations that had to come from the investigation itself, not from something the department had already received from a client. So,
Well, my major concerns were, I think would be legitimate, as to who gets the information, what the access is, what the level of the procedural safeguards involved, and I think that kind of talks about it. Just briefly in closing, and not to dwell, the reason why I asked about child support is because it's mentioned in your literature, and those are the purposes. So I thought it relevant to ask. But thanks for answering the questions.
Thank you.
Representative Lamontagne, are you all set? Okay.
Thank
All
you.
right. Thank you all.
And I want to thank our staff from the Division for Public Health Services and Chairman McDonald, with your permission, we could bring up our representatives from our Division for Economic Stability and also the Division for Program Integrity Integrity.
Thank you. Yes.
And then
please.
followed by the wonderful registrar from the Secretary of State office rounding up. And I think you'll find her testimony particularly enlightening as it relates to safeguarding information.
We definitely need more microphones, that's clear, but
We can
sorry
share.
about that.
We share well. Yeah, good morning. I'm Deb Sorley. I'm with the Bureau of Family Assistance and primarily have responsibility over business and policy for all the programs that we administer for SNAP, TANF, Medicaid, child care, all programs.
And good morning. My name is Lisa Dekatowski, and I am the Bureau Chief for the Bureau of Child Support Services and within the Division of Economic Stability. I've made note of your questions, and I'm happy to try to answer them for you and any other questions you might have today.
Good morning. My name is Tasha Blanchard, and I'm the Bureau Chief for the Bureau of Program Integrity. My units do auditing as well as investigations for fraud, waste, and abuse in the benefit programs.
Thank you.
I think I'll start with just the Bureau of Family Assistance that encompasses all the programs, of which Lisa's then gonna segue off into all the particulars about child support specifically. For the program of eligibility, we are again an integrated eligibility system. The benefit to someone coming in to apply for our programs, it's a one-stop shop, if you will, unlike other states. So if somebody's interested in Medicaid, Children's Medicaid, TANF, SNAP, child care, they can do it all with one application and have one case manager assigned to them to follow them through from start to finish. The key thing about the vital records for us is it is a federal regulation for us to verify citizenship and residency. So it starts at the federal level, if you will, trickles down to the states who administer the programs. So that is our primary responsibility, to obtain that information for all of the programs. If the vital records birth certificate allow that to be something that's simplistic, if you will, for the applicant, we have the information readily available to us. They don't need to provide it to us in any other format, obtain it. I think even getting a birth certificate right now, I think there's a cost incurred if somebody goes in to request that on their own. So it really does provide them ease of access for us to then, move on to other things that we're going to be interested in obtaining from them. Were you looking for me to pause?
No.
Oh, I'm sorry. I didn't want to without it, then somebody can still apply. We just can't obtain it with that ease. And we would have to put the responsibility on the applicant to provide that information to us in a different format. And depending on what they provide to us, we would have to determine whether or not it was sufficient and provided the information necessary for that residency and citizenship. The end result, without the information, we would have to deny their application for program. Again, we're responsible to the federal level and we're audited all the time. So that is a critical part of the client's record. Questions?
Any questions?
None at this time, thank you.
Representative Lamonte.
Thank you, Mr. Chair. Just so I understand what you're saying, if this form isn't completed accurately and goes to vital records and then you're saying then someone who comes in for services and they haven't gone through this process and then has to apply for a birth certificate on their own, it may end up resulting that they don't get the services that they're looking for.
Correct. If that
Okay.
vital record is incomplete or they didn't, release any information to be released to us, if you will, yes, we would have to rely on, I say the applicant, it could be the mother, the father, a guardian, but whoever's coming in to apply for services for that child then has to, on their own, figure out a way to provide us with that information because we must have it.
Okay. Just to follow up, yeah. So how often does that happen that someone does not have, like under the current system, that very rarely happens that someone doesn't have.
Yeah, we're pretty successful with vital records.
Okay. Thanks.
I will add, on our application, there is a section, you might be a little bit aware of, like we identify to the applicant that we will be obtaining that information and they sign off permission. So we have their permission as well.
I have a question. Are you all set? I have a question, and I probably should have spoken to Ms. Chow, and she's still here, so maybe if I need to call her back up later, hopefully she'll still be here, but maybe you can answer this question. Getting back to HIPAA, does this 621 potentially violate HIPAA or our compliance with HIPAA?
What I will say is all of our client files are in the electronic form, and vital records is obtained through an electronic channel as well. I'm not very good in the techie field, so I can just say it all is secure in that way. As far as us requesting and receiving the information, it is then downloaded to our system. It has been referenced that only those within the Bureau that are actually specifically determining the eligibility for that family has access to that information.
Okay. So it's not a clear-cut indication whether it would violate HIPAA or not. Is that potentially? Is 621 in violation of HIPAA or any aspect of that, or? And again, we can move on, and I can ask Ms. Chow to come back up later if that's. Sorry, I should have asked this question earlier.
So, as far as I understand, under HIPAA, the department is a public health authority to have the authority to collect these identifiers from vital records, birth data, and other health data set. So to collect these identifiers is not violating HIPAA at all. To release the data, we also follow, excuse me, we definitely follow the HIPAA safeguard and also the regulation and the process to determine whether this is the data release is fall under the HIPAA public health practice, etc. So I'm not the legal expert or the privacy expert, excuse me, but as far as I understand, the department has the public health authority under HIPAA to collect the data and follow the HIPAA regulation and also the process to release the data.
So it's not clear what 621 would mean in terms of interacting with. It's more of a legal question. It sounds like than a medical question.
Chairman McDonald, again for the record, John Williams, Legislative Director. So the issues with the bill are articulated financial in relationship and also the impact it would have to the programmatic operations of the department. In and of itself, we never identified through the process, and I'm double checking everybody in the audience, that we never identified that the underlying bill had any HIPAA issues. HIPAA still would apply. It would just be, we would be limited with the information we would get under the HB 621, but the bill in and of itself would not create a HIPAA issue or a HIPAA compliance issue. It would just be the lack of getting that information, and whatever information we get would still be protected under HIPAA. I'm looking over, this is intergovernment, I see a smile from Secretary of State, so I was on the right track. Thank you.
Okay, thank you. Okay. Sorry for all the musical chairs there. Okay, please continue.
Thank you again for having us here today. Appreciate the opportunity to speak before you and answer any questions that you have about the Child Support Program. Again, Lisa Dekatowski. I am the Bureau Chief for the Child Support Program for the Department of Health and Human Services. Our primary responsibility for the department is to administer the Child Support Program. The Child Support Program in New Hampshire is a federally required program under the Social Security Act, Roman numeral 4, Part D. part of our responsibilities in the child support program is to establish paternity and or parentage, if you will, primarily legal fatherhood. Certainly, we need to be able to establish a legal relationship between parent and child. And naturally, the birth certificate is a key legal document that we use for ensuring that legal relationship between parent and child. So naturally, when we're looking at vital record statistics, vital record access is authorized under the federal law of the Social Security Act, that the child support programs in states have access to vital records information, specifically birth record, marriage record, death records, paternity status records. That would include domestic status. The way I understand procedurally of how things work is that in when the birth worksheet that is completed is the mechanism that allows us to have the personal identifiers that then carry over onto the birth certificate. The birth certificate is the key record that our program is most interested in, particularly, and all the personal identifiers and information on the birth certificate itself. That allows us to be able to ensure, as I stated, whether paternity has or has not been established on behalf of a child whom we might be providing services to, and to ensure the legal relationship so that we can establish support orders here in New Hampshire on behalf of individuals who have requested for our services. Chairman McDonald, you had referenced in certain circumstances whether or not a participant has applied for our services using our Form 725. I must add, I'm very impressed with that. That you recall.
The memory hasn't gone yet.
Thank you. That is correct. That child support individuals must apply for child support services for us to become involved if they wish to. Here in New Hampshire, this application 725 form is what we use for that. In those circumstances, we then collect the appropriate data to be able to open up a Title 4D child support case. That does include names, date of birth, things of that, demographic information to be able to establish a case. Representative Markell, you had referenced concerns about safeguarding and privacy. There was also the reference of a domestic violence or family violence form. The program does, in fact, have a specific safeguarding form that we have our participants complete. Relative to whether or not there are any concerns with family violence. That is required under the federal law for us to have that under the Title 4D program. We are also subject not only to the Federal Office of Child Support Enforcement confidentiality restrictions, but we're also subject to our own New Hampshire RSA 161B:7, which specifically outlines the specific purposes for how we can keep, retain, and or release records that are within the child support program's possession. And we follow that to the T. Internally, we have safeguards in place where the law only allows for the child support program to be able to release records to individuals to which they are authorized to be able to have such records. And we do have internal procedures for how we go about participants requesting for that or not, and whether or not they can be provided or not provided, in alignment with the department's safeguarding procedures as well. So it's a multi-layered safeguarding approach for the protection of records in which the child support program may need or required to have to be able to carry out our program operations. With that being said, again, I think the concerns that the child support program would have in relation to House Bill 621, just high level, in addition to what we've already submitted for the written testimony, is just that, depending upon how the bill is should it come forward, depending upon how it is written, having access to the vital records information is a key component to the operations of our program to ensure that families are receiving child support, to ensure that we can locate parents, to ensure that we can establish that parent-child relationship, ensure that children are receiving both their medical support needs as well as their financial support needs, and to ensure that we can establish paternity for as many children as we can serve here in New Hampshire. And so I would just, defer to that. And if there were any other questions regarding the child support program and how we use and access the data, I'd be happy to try to answer those for you. Or at least if I can't, I will get you the answers.
Representative Lamontagne.
Thank you, Mr. Chair. Thank you, and thank you for taking my question. I hadn't really thought much about these questions before, and when the issue of child support and paternity came up earlier, thought, oh, well, you can do a paternity test, and this information wouldn't be that important. But say there's a birth and of a civil union, and there's two women in the civil union. The other parent is a woman, and so there was no a paternity test wouldn't prove anything. But here you have a record that these two individuals are saying we are going to be responsible for this child in a way, right? And that's where, say the union fell apart, one parent is left taking care of the child, and the other, without this record, really, you have no record that they had promised to be a parent in a way by filling out this form. So in that case, any kind of paternity test wouldn't back up this assertion. So I don't know that much about child support laws, but would a parent who's not the biological mother, but is on this form as parent B, are they liable then for child support, even if they have no biological relationship?
Thank you, Representative, for the question. So simply, the answer is yes. If a legal relationship has been established between a parent and a child, and either that has been acknowledged through vital record or has been acknowledged through court order or some form court of law, whether that be the courts, an adoption or anything of that nature, there's a legal relationship established with that child. Should the parents have a legal separation or a legal divorce in some manner, or then yes, both parents are legally responsible and liable for their financial and health well-being of that child. So the access to the vital records are essential.
Thank you.
Thank you.
I think the law says, was it natural, adoptive, or step relationships? And I remember I actually had a case like that in Keene many years ago. And a step parent, even if it's a civil union type of situation, affects eligibility also, right? In terms of that income has to be included in the case and so forth.
That's absolutely correct.
Representative Markell.
Just by way of comment, I noticed the form is from 2021. As a practicing family law attorney, I can also tell you that by statute, I think around January of 2011, undissolved civil unions became marriages by operation of law. So that's really I would be less concerned about that. But I do want to thank the panel and certainly everybody who testified, because they had some privacy concerns. And I wanted to thank you for providing, illuminative information and to help us reach a decision.
Well, thank you for having us. We are here to answer any other questions you might have.
Mrs. Blanchard, did you want to speak? I don't know that you got a chance.
That's
Mrs. Blanchard had to put up with me quite a bit when I was over at the department, so I don't want to slight her.
Thank you, Representative McDonald. I just wanted to point out from the perspective of the auditing and the fraud, waste, and abuse that for SNAP benefits, if the error, no matter how the error is determined, if there's an error based on the beneficiary's information or an error based on a state's interpretation. Under SNAP benefits, the recipient is obligated to pay back all those benefits that they received in error, no matter if it was intentional or not. So that can have a significant impact if we're trying to independently verify information, and we need all the data we can get to do that.
If I could follow up on that, at least when I was there, it sounded like, you know, if it was an agency error, there was a limited time frame and a limited scope. Is that still true, or is it not?
Yes, there are limits on the time frame and the amount. It has to be over a certain amount, unless the error is found on a quality assurance review. If it's found on a quality assurance review, there are no limitations.
Thank you. Also, and again, this is, hopefully I don't have to bring anyone else up, but I'll bring Ms. Charo up or Attorney Williams back up. Just to clarify the potential fiscal impact, and it's actually stated in here, it looks like $11,385,296 could be potentially affected in federal dollars if this bill were passed. Does that sound correct? Okay, so department-wide, it's greater than that. And do we know that figure? Is that in any of this information, or? Yeah, that would be very helpful. We're considering the bill, and we want to know its full impact or potential impact. So that'd be great to know that number as closely as possible. Any other questions for these three folks?
None at this time, and thank you.
Representative
Thank
Montaigne,
you as
are
well.
Okay, thank you all.
Kristen, are you coming up? Hello, I'm Kristen Martino. I am the Registrar and Director of Vital Records, which is part of the Department of State. So just to start off, I'm going to keep my testimony brief because I don't think the impact is quite as high as it is on Department of Health and Human Services. We were not contacted in the beginning for a fiscal impact on this. I can tell you it's fairly minimum for what I can tell. We would have to redo our birth worksheets, which is about $25,000 for us to do, and the bill does not appropriate any funding for that. On top of that, we would have to make some changes potentially if there is this opt-out function. We'd have to go into our software. We use a software database called Nevern Plus. The hospitals use that to key in the records, and then that's how we get our information to disseminate out to DHHS, and it's also what your town clerks are using to access to issue certified copies of birth records to folks. We would have to have the ability to go in and add that opt-out function to our software. If it's a simple, just little, we're going to opt out of specific information, one fell swoop, it would be probably a very minimal impact. But if this is one of those carte blanche kind of things where the mother can go and pick and choose what different things she wants to submit to DHHS or not, that could get costly, and I can't provide you with a number on that without knowing the exact scope of where the sponsor was looking to go with that. One of the other areas, or the biggest areas for me, are that I very, very carefully follow our statutes when it comes to how we're releasing vital records or releasing the statistical information, all of that. I noticed that there was no definition provided for personal identifiers, and we actually currently don't have one within Chapter 5C in our definitions, 5C1. Nothing in there determines what is a personal identifier, so it's kind of broad. I would just be looking for more guidance as to what exact personal identifiers are we talking about here so that we could comply with the statute. And then we also had recognized that there were some possible contradictions to other existing statutes should this bill pass. One of them is 5C4, which basically talks about how we're collecting the data and then giving that to Health and Human Services. We are designated under, with the federal government, Section 306E of the Public Health Service Act, 42 USC, Section 242 KE,
which is this is in RSA 5C4, so I know I just rattled that off rather quickly at you. But we're designated to collect, compile, coordinate, and disseminate all that vital records information and statistical information. This statute also addresses that we have to share our information with the Department of Health and Human Services, and this bill does not address that statute at all. So it's creating a contradiction where it's telling me I can't, but then I have this one saying I need to. We have another one, RSA 5C9, again, backs up that the Department of Health and Human Services has a direct and tangible interest in our vital records. And the bill doesn't address that statute telling us that we shouldn't be giving them that information anymore. And then the other statute, it's actually not our statute, but because we reference it several times throughout our chapter, it's actually a Health and Human Services statute. It's 12624C, which tells everybody that the department shall have, and the department meaning Health and Human Services, shall have a direct and tangible interest in vital records data, including personal identifiers. The Secretary of State shall provide continuous electronic access to the department of the entire contents of the data files on a 24-hour basis, 7-day per week basis. So basically, this bill is also not addressing that statute at all. So if it's telling us we can't do it, but then I have this one telling me I have to do it, it again creates a contradiction. So I'd be looking for some more concise language on how I would handle that. My final concern is basically it's contradicting my duties as the state registrar as well. So when a mother has a child at the hospital, they complete the birth worksheet, which I think you had copies of. That information stays at the hospital. We don't get it at Vital Records. It goes to whoever their birth registrars are. And that person at the hospital enters it into our Nevrin system, which is where it comes to us. Once it's entered, they lose access to it. They can't see it anymore. And then it comes to us and it's disseminated down. They're not giving it to Department of Health and Human Services. They're putting it into our system, and we give it to Health and Human Services. The way this bill is written right now, it describes the hospital as the entities that is redacting this information, not my division, which would be the more appropriate person to do that, or appropriate division to do that. The dissemination of the information falls to my duties under the statute that defines my position with the division, not the hospital. So I still see the language as being problematic for me to work with as is. And we did express this to the sponsor and offer to provide some information, but it didn't happen as of yet. So that's what I have. If you have any questions, I'm happy to answer them.
Representative Lamonte? Sure.
Thank you. And thank you for taking my question. So just so I understand, this is a paper form that's filled out, and then at the hospital it's entered in.
Yeah, it's entered by the
System.
hospital, and my understanding is it goes into that person's health file. We don't even see the forms.
Okay, and then so it's entered into the electronic medical record, and presumably the hospital keeps the paper copy.
Yes, and they're entering it. So the electronic medical record we don't have access to. They're entering it directly into our vital record software known as Nevern Plus. So they're actually going in and accessing there's various modules in there for all the other events. They go into the birth module and they key that record on.
Yeah. Okay. Thank you.
You're welcome.
No questions at this time.
Okay.
Could I trouble you to list those statutes? You don't have to go into detail of what each one is, but just give me the numbers.
Would you like the list?
Oh, that'd be great. Yeah, thank you.
It's highlighted, but my color printer wasn't working, so it's red.
May I keep this copy or?
Absolutely.
Great, thank you. Oh, do we already have it? Oh, okay. Well, thank you. I haven't had a chance to go through this pile of papers here. But thank you very much. Anyone else wish to speak? Mr. Bradley, you've been referenced a number of times, but it looks like you're all set. All right. Okay, well, thank you all very much. This is all very helpful, and I don't know if we want to continue to, what the will of the committee is, if we want to digest any of this and have a subsequent meeting, or if we want to maybe have a recess and talk among ourselves, or what do you want to do?
that.
Okay. All right, we're going to have, 15 minutes, is that sufficient, or? Yeah, we're going to have a quick recess and we'll be back. Thank you. Okay, thank you for your indulgence. I'd like to reconvene the subcommittee on HB 621. We did have a brief discussion. And Representative Markel, would you like to make a motion in terms of what we will recommend to the full committee on Health, Human Services, and Elderly Affairs?
Yes, thank you, Mr. Chairman. I'm going to I move that we ITL this bill.
And Representative Lamontagne.
And I second that motion.
Okay. And is there any other discussion on this matter?
Well, I think the weight of credible evidence that was presented, the testimony that was presented, the controlling statute, the statutes that are likely to come into play, in summary, and also saying that while there is a right to privacy in this state, nevertheless, I'm not sure that all rights are absolute under all circumstances. And the credible testimony that I heard was that there will be adequate procedural safeguards to protect the information. And so it's my view that the information that's gathered with the adequate safeguards in place does not unduly burden the right to privacy. So that's how I'm viewing it.
Representative Lamontagne, do you have anything further?
Yeah, I would just add that I do feel like this personal information is already protected in terms of privacy, but the harm that could result by not collecting this data is an important reason to ITL this bill. And I also feel like, asking giving the birth mother, right around this birth period, do you want to collect this data or not? She may say, oh, maybe I don't want to give this information, and not understand really the future complications that might hurt her by not having all this data collected. So that's why I support the motion.
Okay, any other further discussion?
None from me. Thank you, sir.
Thank you. Okay, so the motion is on the floor of ITL on HB 621. All those in favor indicate by saying aye.
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 Aye. None are opposed. I'd call for a nay vote, but I don't know who I'd call it to. So with that, the motion carries unanimously, and that'll be so recorded, and that will be the recommendation to the full committee when we have executive session next month. It would be helpful, Ms. Rogers, if I could get that department-wide financial impact. That'll be, I think, important perhaps for the executive session and also for the any potential floor discussion at the full House meeting in January. So, please, and again, I realize it may not be an exact number, but a close ballpark would be really helpful. Anyone else have anything pertinent to this discussion before I adjourn? Okay, thank you all for being here. Thank you all for your input, your testimony. It was very, very valuable. And with that, I'll adjourn the meeting.